The United States Court of Appeals decision that was released on Friday that struck down Trump's tariffs was a bad one. It ignored Supreme Court precedent, the legislative history of IEEPA, the law in question, and failed to distinguish between the reciprocal, also known as Liberation Day tariffs, and the tariffs imposed on Mexico, Canada, and China, specifically to address those countries' role in America's fentanyl crisis. Before we go forward, it's important to define the acronyms IEEPA and TIWA. IEEPA refers to the International Emergency Economic Powers Act. TIWA refers to the Trading with the Enemies Act. TIWA is IEEPA's predecessor. IEEPA adopts the language of TIWA's Section 5B, the relevant part, verbatim. In 1971, Richard Nixon used TIWA to impose a 10% tariff on all imports into the country to address the balance of payments crisis caused by him pulling the country off the gold standard. A company named Yoshida sued, arguing that Nixon didn't have the authority to impose the tariff. In Yoshida, the U.S. Court of Customs and Patent Appeals ruled that Nixon did have authority under TIWA to unilaterally impose the tariffs. Supreme Court precedent dictates that when Congress reenacts a law without change, it adopts the judicial interpretation of that law. Quote, Congress is presumed to be aware of an administrative or judicial interpretation of a statute and to adopt that interpretation when it reenacts the statute without change, the Supreme Court said. Here, Congress was aware of the court's interpretation. It was discussed in the House hearing by multiple expert witnesses before IEEPA was passed. Then Assistant Attorney General Anton Scalia wrote a letter expressing the DOJ's view that said the law was being used by the president in expansive ways and that he was aware of no congressional disagreement with such practice. In light of all this, Congress passed IEEPA without changing the statutory language of Section 5B of TIWA, which is the question here. The opinion of the court in this current case ignores this legislative history and ignores the Supreme Court precedent saying that Yoshida must be followed. Instead, they substitute binding Supreme Court opinion for their own opinion. This current court said, quote, it seems unlikely that Congress intended in enacting IEEPA to depart from its past practice and grant the president unlimited authority to impose tariffs. The court is not in the business of probabilities and odds making. They should follow Supreme Court precedent and not depart from it in this foolhardy way. They go on to argue that even if Congress did adopt Yoshida's view, the powers recognized in Yoshida are not broad enough to let Trump impose his Liberation Day, aka reciprocal tariffs, or his fentanyl-related tariffs. In doing so, the court fails to distinguish between Trump's universal reciprocal tariffs and his fentanyl-specific tariffs imposed on Canada, Mexico, and China. The court is also incorrect in its historical account of Nixon's tariffs. The court describes Nixon's tariffs as temporary, however, Nixon's own words indicate the opposite. Nixon is quoted in a September 1971 New York Times article saying, quote, if all we are seeking were a temporary solution, temporary would be very brief. But we are not seeking a temporary solution. The tariffs ended up being temporary because they were lifted after 5 months, but at the time they were described by Nixon as being indefinite. And with regard to the April Liberation Day tariffs, we're not even outside that 5-month window described by the court here. The court in Yoshida also did not establish a hard and fast rule that 5 months is the cutoff for tariffs to be constitutional. Again, the opinion's failure to distinguish between the Liberation Day tariffs on every country and the fentanyl-specific tariffs on Canada, Mexico, and China is also a big error. In his executive order pertaining to Mexico, for example, Trump accused the Mexican government of having a, quote, intolerable alliance with the cartels who are trafficking drugs into the country. The cartel's grip on the Mexican government is well documented, and one Mexican senator even appeared on Fox News this past week to request U.S. intervention.
President of Mexico is furious. She's calling Mexican Senator Lili Tellez a traitor for coming on Fox Noticias with me a few days ago and saying this.
The help from the United States to fight the cartels in Mexico is absolutely welcome, and that is how the majority of Mexicans feel.
Politicians who try to crack down on the cartels in Mexico are often killed. Yesenia Lara Gutierrez, who was a hero, was a candidate for mayor in the Mexican city of Veracruz. She was gunned down by the cartel on Facebook Live during a campaign rally. Her daughter was killed and 2 other innocent people were killed. The cartel's grip on the Mexican government and the U.S. response to it was the spark for a brawl in the Mexican Senate this past week. The plain language of IEEPA gives the president the power to investigate, block, regulate, direct and compel, nullify, void, prevent or prohibit any importation or exportation of any property in which any foreign country or national thereof has any interest by any person, in order to address an unusual and extraordinary threat which has its source in whole or substantial part outside the United States to the national security, foreign policy, or economy of the United States. So you see it says any. This is very intentionally broad language by Congress, meant to give the president a lot of power to fight these specific threats. The fact that a neighboring country is a narco state that's throwing fentanyl into the country and the politicians in that country who are critical of that are being executed, I think that's a pretty substantial threat. Would you say that's a substantial threat? I think so. These tariffs are meant to bludgeon foreign countries into correcting their behavior. And correct their behavior, they will. And they have. The New York Times reported in March that as a result of the February fentanyl tariffs, the Mexican government is starting to crack down on the cartels in unprecedented ways. This is a necessary tool for the president to defend the country and conduct international affairs. It is not for judges to strip the president of this legitimate and congressionally delegated power. Even if the court were to find that the reciprocal Liberation Day tariffs on every country were too broad, which I think would be a mistake in light of Yoshida, and in light of the fact that Nixon imposed a 10% tariff on every country, the fact that they failed to distinguish between the reciprocal tariffs and the fentanyl-specific tariffs is a disgrace, and it's really abysmal. Trump is appealing to the U.S. Supreme Court, and the United States has already collected $150 billion of revenue from Trump's tariffs. It would not be popular or good if Trump were ordered to return the money and take it out of the U.S. Treasury. The court may be setting up an Andrew Jackson moment here, similar to how Andrew Jackson said, the court has made their decision, now let them enforce it. I'm not advocating for that approach, but this could very well be where it's heading, depending on what the Supreme Court decides. The Court of Appeals' decision here is a brazen interference with Congress's legitimate delegation of emergency power to the President of the United States. The Supreme Court should overturn this dumpster fire of an opinion quickly.